We welcome you to the ANU ILS Career Series, Unravelling International Law. We acknowledge the Ngunnawal and Ngambri peoples, traditional custodians of the lands on which this interview is recorded. We pay our respects to the elders, past, present and emerging, as well as any Aboriginal and Torres Strait Islander viewers. We hope you enjoy episode 3.
My name is Angelique Nellis and I'm the Careers Director of the ANU International Law Society. We are very fortunate to have a highly distinguished and renowned guest join us virtually for the third episode of our video series. She has soared to the heights of the international law domain with a plethora of achievements, including being the inaugural president of the Australian and New Zealand Society of International Law and being appointed as a judge ad hoc of the International Court of Justice. Despite her busy schedule, she is no stranger to the ILS, as we've been very fortunate to have her actively involved in the society over the years. On behalf of the ANU International Law Society, I would like to warmly welcome the remarkable Professor Hilary Charlesworth AM. Professor Charlesworth, it is an honour to have you on our video series. Thank you so much for joining us this afternoon.
Angelique, it's a pleasure. Thank you for asking me.
Whilst there is so much I actually want to discuss with you, I will unfortunately have to demonstrate some constraint. So today we will primarily focus on your career, experiences, and gaining your perspectives on the trajectory of international law. So the first question. In a previous interview, you noted that during your time as an undergraduate law student, you did not especially enjoy studying law and contemplated the option of dropping out. That is, of course, until your final year in which you studied international law. Hearing you say that was actually quite a refreshing reminder of the realities that a lot of law students face. However, by finding international law a subject that you enjoyed, you went on to partake in numerous activities such as the oldest and largest international moot competition, the Jessup Moot. So what advice would you give to law students who may be in a similar situation, that being they're interested in international law but are unaware of the activities that they should engage in?
Well, thanks, Angelique. It's true. I said that and I still, even though it was a long time ago, I still remember how disengaged I was as a law student. Of course, in those days, those bad old days perhaps, we did law as undergraduates. I think a lot of law schools now have moved, certainly at Melbourne, we've moved to doing a JD program when people come in with a lot more knowledge, and that may well change things. But I can do no better just initially to pass on some advice that the late, great James Crawford, the brilliant Australian international lawyer who's only recently died, who was, of course, an elected member of the International Court of Justice. James Crawford always used to tell students, I've been told this and I've seen him do it, if you want to be a good international lawyer, first be a good lawyer. So one thing that I think it's important to realise, and I wish I'd known James then and I'd heard that wisdom from him, because I think, as I've earlier described, I found international law only in the final year of my law degree, and finally found a subject that I was truly interested and engaged by, and absolutely loved it. I did then go on and work for a lawyer and did my articles, worked in a law firm in New York, worked as a judge's associate. But I hadn't realised how important getting to know the law was in order to be a better international lawyer. So the first thing I would say is to students who are studying this, don't specialise too early. If you really feel a yearning towards international law and that's something you'd like to pursue, it's really worth your while to accrue general legal skills. So don't see time spent doing other things, other forms of legal practice, whether it's in government, whether it's in private practice, whether it's in the civil society sector. All of those skills are going to be really useful. So I guess what I'm saying is don't hasten into the profession of international law.
That's very fascinating, and I think that's definitely a very good point that a lot of students may may find valuable. And now onto the second question, we may move on to your further education. So you obtained your education at the University of Melbourne and Harvard Law School. You previously noted that during your time at Harvard, it encouraged you to pursue a career in academia. As you currently hold visiting appointments at numerous universities such as Harvard and the Université de Paris, what would you say to ANU students contemplating whether to explore further studies overseas or in this current climate virtually from international institutions? What do you believe are the benefits in this regard?
Well, for me, I suppose I found my overseas studies in the United States were just a complete eye-opener. It's funny, I found some old diaries of mine the other day. I must say I've thrown them all out since. I was so embarrassed reading them. But some of my diaries about my first days in the United States at Harvard Law School. And it just brought back in a great rush the excitement of an extraordinary institution. Of course, the law students there were all JDs, so they'd all done other things. So you were straight away starting at a different level. And perhaps it's quite unfair today to contrast a completely graduate law school as Harvard was, and an extraordinarily well-endowed one, with Australian legal education in the 70s and 80s, which was perhaps underfunded and not taught particularly imaginatively. But that experience for me was quite profound. I think partly because I was in large classes, but I was also in very small classes. I still recall a brilliant course on anthropology and law taught by the great legal anthropologist Sally Falk Moore, who's still alive, who is an astonishing woman, who taught us about the Sudanese legal systems. And so it was the range of subjects that no Australian university at that time could possibly offer, the specialist nature of them, very small classes in many cases, and the extraordinary library. And of course, the great thing was, at least in the LLM program at Harvard, were the immediate and close contact with people from all around the world, many of whom I'm still in touch with, still very friendly with. So that was a really formative and exciting time for me, just to see the way legal education could be quite different. And I think it was that I had brilliant lecturers who, instead of, I'm going to slightly over-characterise here, but I think some of my worst lecturers in Australia, and I do want to emphasise I did have some wonderful ones as well, but perhaps some of the more dull lecturers would simply stand up and, in one case, read out the relevant statute to that area of law, would simply read it out. And we'd really get up to section 1, subsection 1, Placidum 1, Roman 1, and it would be read out. This was pre-internet, of course, and we would all carefully copy the words of the statute into our notebooks. Then you go to Harvard and the professor walks in, and the first thing he will say, he will pick on you. I still recall the time when I was actually pounced on in class and said, what do you think of what the Supreme Court of the United States has just decided in this case? I was mute. I just could not speak. I was so sort of shocked, but I slowly got used to the more Socratic learning. And I think it was the way that you could see that legal education, instead of the dull and rather deadened style that I had experienced, along with some excellent teaching, that really made me think this would be a wonderful thing to engage with. When I landed up at Harvard, I'd actually hoped to go home and go to the bar. That had been my plan. I'd been a judge's associate, and watching barristers up close, I thought, I would like to do that. But I think then Harvard really made me think, no, I think legal education would be really, really rewarding. And I've never regretted that.
Oh, wow. And I think it's really interesting how you mentioned, going overseas and kind of experiencing that different style of teaching. I know when I was at the ANU, they offer an elective now called comparative law, so Australian and the US. And we got to do that virtually with the University of Alabama. And it was just absolutely fascinating, even like the different perspectives of the way that things were taught. And we were very fortunate with the professors that we had as well. It's a very unique and different experience. And, although the education is fantastic here, getting those sorts of experiences internationally too is definitely something I think we would both recommend. And I think now we can delve more into your commendable international experiences. So firstly, during your time as an appointed judge ad hoc of the International Court of Justice in 2011 with the whaling in the Antarctic case, and 2019 dealing with Guyana-Venezuela border dispute, you were seen as an outstanding example of the breadth and depth that could be brought to superior courts. How did you prepare for your appointment, and what was a memorable experience for you in that regard?
Well, it was all, and the Guyana case, of course, is ongoing, so that remains, I would say, the same thing of it. Well, of course, at first it's very daunting to suddenly go from teaching about an institution in the case of the whaling case, then fronting up in the Palais, in the Peace Palace in The Hague, and thinking, oh, I'm really here. I found it quite overwhelming at first. It's an absolutely astonishing building, and you're really conscious of the weight of history. It was, built in the early 20th centuries, and the great hope was this was going to, the word of one commentator was to literally turn swords into plowshares. It was given a lot of, so it was astonishing and a huge privilege to be able to just be in that building. What I was struck by, of course, as an ad hoc judge, you do have a different status to the elected members of the court. You're there just for one case, and all the other judges are getting on with their extremely busy lives. They're fitting in the one case you're focusing on with all their other cases. But I found them extraordinarily friendly. I was, of course, very much in awe of them, and but was struck by their friendliness, their helpfulness. The main thing I was struck by, seems a bit embarrassing even to admit this, but I should have thought this, was the tremendous work ethic at the International Court of Justice. I shouldn't have been surprised, because I have worked, as I mentioned before, as an associate in the Australian High Court, but I was very struck by the great seriousness and weight given to all the arguments, the way that I have seen in domestic cases, sometimes judges perhaps getting a bit cross with counsel and saying, counsel, I suggest you don't proceed any further, just stop that line of argument right there, giving a pretty big hint, this is not a useful course. And I've certainly seen that happen in domestic courts. But in the International Court of Justice, because the parties are, of course, states, sovereign states, the court's very aware of that, and perhaps listens to every argument with great deference and great seriousness. And the judicial deliberations, I hadn't expected them to be so detailed or so long. They take place, obviously, after oral argument. And the detailed, sophisticated discussion that takes place on all legal points. And then you have, of course, the added interesting issue of translation. All judgments of the International Court of Justice, of course, are rendered in English and French. And you find either, depending on the case, the Francophone or the Anglophone judges making points, well, that's all very well to say that in English, let's say, but the French translation does not capture that nuance. So here are some suggested words. So it was the detailed, painstaking work on arriving at a judgment that I was both very engaged by and perhaps, yes, very, very initially, I hadn't really thought through the way that the court would work, but it's exceptionally hardworking and detailed. Now, each time I look at an ICJ judgment, I read it in a new light.
That's actually very wonderful to hear, and I can actually understand what you're talking about when you say that it was quite an overwhelming experience, seeing the peace pals for the first time. As I mentioned to you before, I was a Hague Scholar in 2020, and I think because it was part of the Hague Academy of International Law, you actually taught a winter course there in 2019, the general course?
Yeah, I taught a summer course, actually. I only say that because I was very glad it was summer and not winter. Yes, in 2019, I realise now how lucky I was, because I think that was possibly the last pre-pandemic course that was able to be taught. If I'm not sure if I'm correct. There may have been a winter 2021, but
I think the winter 2020 was the one that I went, and then we were able to go, and then
after
it was
that,
February, and then complete
online. So you had the last of that. So yes, I was just before that, and that was a fantastic experience. I'd given a week-long course, I think, I don't know, perhaps in about 2010 on international law and democracy. And I was doing the general course, which lasts for 3 weeks. And I decided to try a topic that I had always been interested in, but I didn't really feel I knew a lot about, which was art and international law. And I've always been not at all expert, but had a great interest in the visual. And I thought about trying to tie visuality and international law together. Of course, there's wonderful work on visuality and law generally, and people like the ANU's own Professor Des Manderson is an absolutely world-renowned scholar in that field. But few people, of course, there are some exceptions, few people had really thought about the way visuality works in international law. So I gave 15 lectures on that topic. And the best part of it certainly were my PowerPoint presentations, because, of course, they were just full of artworks. I think some students enjoyed it very much. I mean, I know in the class there were some practicing artists who were also international lawyers who spoke to me. They enjoyed it. I must admit there were probably some students, in fact, I heard from some of them, who said, hang on, we've come to the Hague Academy for some doctrine, and what have we got? We've got this rather strange tour of the ideas of visuality and art and international law. So, I think it was perhaps had a mixed reception, but for me, it was a wonderful, wonderful experience. And of course, at the Hague Academy, I think there were in the summer 300 or 400 students, again, from all around the world. And the ideas that they brought, I was very influenced by ideas, and I encouraged them to show me artwork that really meant something to them. And I recall particularly students from Mali and Cameroon who introduced me to artworks I'd simply never encountered. So it was a wonderful time for me, and I'm just almost finished writing those up as a book. So yeah, they should come out, I hope, before too long.
Wow, that's very exciting to hear. And I think that's such a unique and refreshing kind of perspective to things, because you see there's an increase now in lawyers not, just knowing the black and white doctrine aspect of law, but, specializing in different areas. And I think it's a very unique take focusing on art in that sense. And during my time as a Hague Scholar, I was actually able to focus on a few of the cases that you sat on, but also another thing that we focused on was different approaches to international law. And I think going on to our next question, you have been seen as a pioneer in international law, focusing on a feminist approach, and a leading scholar in the field. When asked in 2015 whether you believe feminist theory in international law is now mainstream and essentially that the mission had been accomplished, you responded by saying not at all, explaining that whilst the vocabulary has changed, the political agenda of the ideas have not, with many feminist concepts being weakened or reduced to simplified ideas. In 2021, have you seen any further progression? And moving forward, how do you think it will influence the trajectory of international law, both in the academic and practical sphere?
Well, I think that I think that there has been, since I wrote with my dear friends and colleagues, Christine Schinken and Shelley Wright, an article on this topic many years ago. I date it to the birth of my first child, my daughter, and so I know exactly how long ago that was, because I was trying to finish it when I was trying to keep her quiet and hope that I get 5 minutes between keeping her quiet and writing. And now she has her own child. I think, oh yes, I remember that time very, very well. But so it's very linked with the birth of my first child. But we thought what we were saying then, well, I don't think it was particularly theoretically sophisticated. It was just making a very basic point. Where are the women in international law? And where can we see them? Where do they appear? And secondly, what work is the idea of gender doing in international law? And as to the first question, it wasn't very hard to show that there were very few women in the heartlands of international law. Just let me take one example, and that's the International Law Commission, which committed international lawyers will know is a really important body set up under the UN Charter, and its idea is to sort of promote the progressive development of international law, a very prestigious body to which you have to be elected by the United Nations. And there has only been one Australian ever elected to that, and that's the extraordinary James Crawford, whose death we're all mourning. So it's had 70 years of existence, and in 70 years, it's had a total of 7 women on it. It has 34 members. So that's just an example. Now, you'd say perhaps at first sight, okay, there's something a little wrong here, because there have been, for at least the last 30 or 40 years, there have been equal numbers of men and women in law schools. So it's not lack of a pool. What is it? And there's been very interesting discussions of what this is. So it's not for lack of qualified women. If you look a bit further, there are just quite a few ingrained practices in the international community, I think, in all countries. So this is a very prestigious position. And typically, when you look at nominations, people who are nominees are people who have pretty top-drawer, classic CVs that echo a male life. So, for example, no interruptions, sticking at one thing and really becoming expert in that field. Slightly more offbeat or unfamiliar backgrounds don't seem to be put forward by states as regularly as nominees. I do note a really important exception, and that's our close ally New Zealand has currently nominated a fantastic New Zealand lawyer, Penelope Ridings, who's I think will be an outstanding candidate for the ILC. And I was thrilled to see that Penelope was being nominated by New Zealand now for membership of the ILC. But even, and let's hope that she's elected, she's going to form part of a tiny minority. I only dwell on that because that's quite a nice example of something is going wrong. So in the heartland of international law, the one exception to this, that's such an interesting exception, is the UN committee that monitors the Convention on the Elimination of Discrimination Against Women. So it's it's a UN treaty body that has 23 members, and 23 of them are women. And one of them, I should add, is a very distinguished Australian, former Senator Natasha Stott-Despoja, was actually nominated last year and elected, and she's certain to make, I think, a brilliant contribution to the CEDAW committee. But if you look at other committees, for example, the Committee Against Torture, and so on, the so-called mainstream treaty bodies, you invariably find a majority of men. So we don't see a lot of women in international law. That remains the case from when we first wrote about this. There have been some changes, but they haven't been profound. And if you told me 30 years ago, these are the changes you'll see, I might have been a little bit disheartened about that. On the International Court of Justice, we have the first woman to serve was Dame Rosalind Higgins of the United Kingdom. She was the only woman during that time. Currently, there are 3 women on the court out of 15 elected judges. Judge Shui from China, Judge Sebatinde from Uganda, and the current president of the court, which is really significant, Judge Joan Donoghue from the United States.
Wow. And from your expert advice, what would you say we could do to improve that? Maybe even, the female identifying individuals at ANU, or from a wider scope in Australia. How can we improve this?
Well, I think it's always, and I think young people, new people starting on their career, I often think what I didn't realise when I was that age and stage, you have a lot more persuasive power than you think. So people like me who've been saying the same old thing for many years, I think people say, of course she's going to say something like that. But I think to have new committed voices pointing out to government, pointing out publicly, this is poor, we should do something about it, I think that's really, really important. And I mean, there have been so many debates, of course, in Australia this year about the issue of women in our federal parliament. And I think there have been a lot of very wise things said there. And people have made the point, look, we don't know, let's say, if you had equal numbers of men and women representing all of us in federal parliament come that happy day that I hope I live long enough to see. We don't know for sure. We can't show scientifically that the decision-making will be different or even better. I don't think we actually know that. And in fact, studies, political science studies of the impact of women show that party affiliation is very important. But even if we don't know, I think anybody who's been on a committee or a group that has equal numbers of men and women senses, perhaps, I mean, there may well be differences, but senses that they work better because you simply have more experiences around the table. Or that's my observation. I've been on plenty of committees where I've been the only women, and I've been on committees where there is balance. And I truly believe, my experience is that they work much better because you just have a greater breadth of experience and ideas to draw on. But I think the issue is not necessarily saying they're going to work better, but it seems to me it's a very basic issue of equality. If we're not taking the right to representation seriously, it matters. And we know that it goes on to affect younger generations. There are plenty of studies that show you have to be able to see someone. It's so advantageous to see someone, a woman becoming Prime Minister or being Foreign Minister or being Minister for Defence or being Attorney General. All of those things have a significance quite beyond the actual person in the office. It really shapes the possibilities for younger people.
And I think what we discuss is definitely something future and current legal scholars and practitioners should be aware of and engage with. And I think that ties quite nicely into our final segment, and that's focusing on a lot of the human rights work that you've done, which is a major aspect of your career. In episode 2, we were fortunate to interview one of your great influences, the Honourable Michael Kirby. You previously noted that his ability to shine a light on human rights issues resulted in you having a great respect for him as a leading legal scholar. Having said that, you've gone on to make your own mark with your laureate project focusing on the international human rights system, and you may be able to explain this better than I would. But the grasp of it all was that you were seeking to answer the question: why are international human rights standards widely accepted in theory, but so hard to implement in practice? So, in your research and experience, what do you believe are the biggest changes that should occur in the next 5 to 10 years to increase the ability for human rights standards to be effectively implemented?
The biggest thing, and this has been an issue for always, is for the most important translation of human rights standards is always at the national or the domestic level. That's where we need to have them bite. So it's useful and it's valuable to have all the different institutions and programs internationally. But at the end of the day, for all of that, the way it's going to influence people's lives is actually for it to be translated domestically. And in Australia, as many people have pointed out, and Michael Kirby has been such a consistent making this point, excuse me, is we in Australia, and I don't think this depends really on which side of government, I think this is a party political free statement, have always been extremely wary of international standards. And you can trace this actually quite a long way back. So we tend to think that international human rights standards are for the rest of the world. They're for the rest of the world, so they might be something that we bring to the attention of countries that we think need to pull up their socks, and no doubt they do. But I think in Australia's case, we've been quite reluctant to acknowledge that the international human rights system equally applies to us. Famously, there is no Australian Bill of Rights, so we don't have a national mechanism to introduce or to enforce those international standards domestically. Now, of course, we now have 3 states or territories that have them, the ACT, Victoria, and now Queensland.
And sorry, correct me if I'm wrong, but you were the chair that was appointed for the ACT's government inquiry into the Bill of Rights. Was that correct?
Yes, I was. I had that great honour, that great thrill in 2002, chairing a committee that the ACT Chief Minister, John Stanhope, had appointed to look at that issue. And it was a fantastic experience, actually. We're a very small community in the ACT, as you know, geographically not very dispersed, but that was a fantastic year just going around and speaking to a lot of community groups, really small groups. Sometimes you'd go and just speak to groups of 2 or 3 to try to get their views on whether this would be useful. And the ACT, I think, should be very proud of the fact it was the first Australian jurisdiction to introduce some form of a Bill of Rights. But what will be critical, I think, we might find all the states and territories adopting one, but I think it'd be really significant if there was some national move towards a Bill of Rights, for the reason that could be a translation mechanism within Australia for the international human rights standards that Australia has always supported, endorsed, and in fact, many Australian people, governments have really shaped the way that international human rights standards are today. You can go back to Doc Evatt, who was really instrumental in, he was present at the adoption. He was chair of the General Assembly at the time of the adoption of the Universal Declaration of Human Rights. And there have been many Australians since who've really played a very important role in developing those standards. But where we lag, I think, is making them bite at home. We have some mechanisms, the Parliamentary Joint Committee on Human Rights, for example. All of these I see as really good and positive developments, but I don't think they're a substitute for national legislation incorporating human rights guarantees.
And I think that's definitely something that we will keep in mind moving forward, especially as a lot of us as law students, fighting for that. And with that is actually the conclusion of our interview. Professor Charlesworth, I want to thank you for taking out the time to be part of our inaugural video series, Unravelling International Law. As someone who has studied your work and has listened to a lot of your presentations, it has been an honour to interview you. Furthermore, the wisdom you have imparted is sure to assist a lot of my fellow ANU students as well. So thank you once again.
Oh, thank you, Angelique, for asking me. Thank you very much.